Okay, so what's Hugh Edwards looking at now he's pleaded guilty to those offences? Well, to cut to the chase and no spoilers, it's probably going to be about the 200 hours community service, okay? But this gives me an opportunity to talk about what we call sentencing guidelines. And I'll talk about the ones relating to Hugh Edwards specifically, but also just how these things work generally. This is going to be an interesting one, of course, because these are subjects that YouTube doesn't particularly like people talking about. So I apologise in advance for the euphemisms I will be using, but hopefully they won't be too confusing. So first of all, what are sentencing guidelines? Well, there's something called the Sentencing Council. That's an independent body, and basically it sets out recommended sentences for various offences. It doesn't cover all offences, but it does cover quite a lot of them, including these. And what it does, the way it works is, it categorises offences into different levels of seriousness, and also with certain offences where there's a risk to specific victims, it also categorises them by harm. Then it sets out a starting point that's, you know, where the judge will sort of go, okay, for this sort of offence, this is where we start. Then we look at aggravating features and mitigating features, and some of those are statutory aggravating features. In other words, these are features the court think is so serious that they must be taken into account. And then there's general aggravating features that the court might consider should be taken into account. One of my judge friends, he called this sentencing by effing spreadsheet, and there's a little bit of truth to that, but the idea is you get consistency. Okay, so looking at the offences Hugh Edwards has been now pleaded guilty to, it's all to do with photographs of children, to put it euphemistically. And the photographs are categorised into three different areas of seriousness. There's category A. That is photographs of children involved in, if I say sexual activity, involving penetration, sadism, or elements of involving animals. Charming, yeah. Category B, that's images of children engaged in sexual activity but not involving the P word or animals or sadism. And then there's category C, which is images, indecent images of children. Okay, but with none of the above. And then also we look at the different offences and what you've done. And there's possession of the images, distribution of the images, and manufacture of the images, creating the images. Now, rather confusingly, as Dan mentioned on a previous video, Mr. Edwards, hello, has been convicted of making an image. However, that's a sort of rather technical thing, because the making is the fact that you've downloaded these images and they are stored somewhere on your computer's memory. However, the guidelines recognise that that phraseology is a bit confusing, and they say that even though it's described as making, you just treat it as possession. Okay, so if you imagine there's a grid where you've got ABC down the side and possession, distribution and manufacture across the top, and you get the starting points. So say for instance the starting point for category C photographs and mere possession is 1 year's custody. The starting point for manufacturing such images is 3 years. If, however, it's the more serious versions, then that can go up to 6 years. I mean, the maximum sentence for these is 10 years generally. So that's what you look at. You say, right, what have you been convicted of? Now, in the case of Mr. Edwards, some 7 of the photographs were category A, which is the most serious. He's only been convicted, though, of actually possessing them, even though the offence is described as making, because, like I say, it's all that to do with the hard drive thing. So the starting point there will be 1 year in custody. What's the aggravating features? It's things like if they're excessively horrible, if you actively sort out them, the number of images you possess. What they said though is if it's a mixture of categories, well, it all depends. I mean, you can sentence just on the most serious. If, however, it was a case where, for instance, you had thousands of images in category C but only a few in category A, they said in that case you might want to consider, the court is allowed to say, well, generally I'll just sentence on the category C. They don't have to though, because you could actually be done for just one image. What are other aggravating features? It's the age of the victims. It's whether or not you're part of an active community. It can be, seeking, requesting people to make these for you. You hear all these horrible cases where people are convicted of manufacturing photographs, creating them, but they're effectively done to order. Now, one thing actually, speaking to judges who do this work, they say one of the most depressing features about it is that they recognise the same children again and again, and they can tell, as they get older, so they just know they are somehow caught up in this and they're being constantly exploited. And that's why they put a lot of effort into actually tracking down people who do this. I mean, the trouble is it's an international market. The thing is, this also includes what we call pseudo images. It's not a defence to say, well, actually, that's not a real person. I mean, so if they are merely photoshopped, I mean, one guy once got convicted, and as the judge said, he said this was a crude image in every sense of the word, because effectively he just pasted a child's photograph over some pictures in an underwear catalogue. But that counts. But this is going to be even more so in terms of, now we've got AI, because, you can create some very realistic images there. But like I say, it's not a defence to say it's not a real person, because the idea is that we sentence on culpability. What were you intending to do? Not what the outcome is. I mean, that's a general thing in criminal sentencing anyway, because the idea is you should only be sentenced for, what you are in control of. So it's what you do, it's not the outcome. I mean, that's why, attempted murder is an offence. It might be you made a complete mess of it and nobody was actually harmed, but we want to discourage people from even thinking about it or trying it. So, we convict people on that basis. But it works the other way around too. This was a big thing with careless driving. It used to be that there was no such offence as causing death by careless driving, because the argument was, well, carelessness, unlike dangerous driving, it's not something you deliberately do. Everybody drives carelessly at some stage. Nobody is perfect. And yes, while you're supposed to exercise the skills and skill and care of a reasonable driver, sometimes things happen. And a lot of time it's just luck of the draw what the consequences are. I mean, if you're not paying attention for a second and you drive across a zebra crossing, well, there's nobody on it. No harm, no foul, as they say. But what if somebody is on it? I mean, like I say, it's not really anything down to you as to what the consequences are. So it used to be that if it was a death by careless driving, you were just prosecuted for careless driving, and the prosecution weren't even allowed to mention that somebody had been somebody being unalived, as the kids would say, in case it's prejudiced the bench. But people said, well, hang on a second, that's a bit outrageous. How should somebody get away with this? And now there's a specific offence of causing death by careless driving. Ow. But yeah, so I mean, that's pretty much it. And like I say, there are guidelines for lots of different offences. I mean, when we do the advocacy training, when we do what we call narrative advocacy, we quite often get people to do pleas in mitigation. And in the old days, before sentencing guidelines, they just had to go and sort of do their brilliant sob story as to why their person shouldn't be sent to prison, or shouldn't be sent to prison very long. Now, of course, we can say, there's all things where you say, well, actually, what do the sentencing guidelines say about this? When it comes to the sentencing guidelines, the prosecution will set out what they believe, what category they believe the offences are. Okay? The thing to remember in this country is, in the same way that it is not the duty of the prosecution to obtain a conviction at any expense, they don't seek a particular sentence. All they do is they highlight to the court and say, these are the sentencing guidelines. We suggest that this is a category B offence of medium harm or whatever. And then the defence can sort of argue and say, well, no, we say it doesn't fit into that. But like I say, the CPS, the prosecution, they don't agitate for any particular sentence. What else do I need to do? Because like I said, I do these without any notes. But yeah, I think that basically covers everything. I mean, like I say, when it comes, Google, just go sentencing guidance or sentencing guidelines, sentencing council, and have a look. So yeah, to get back to Mr. Edwards, like I say, the starting point for his offences are 1 year in custody, but the mitigation is guilty plea. Generally speaking, an early guilty plea, that instantly gets you a 1/3 discount, okay? And sometimes that can be enough to take something out of the custody bracket. Also things like remorse, seeking treatment, it was a one-off offence. Although in these particular offences, previous good character isn't actually that major a thing. Because the argument is, well, a lot of the time you use your respectability to get away with it. So previous good character isn't actually as relevant as it is when it comes to lots of other offences. However, non-custodial sentences are available. They are in the sentencing guidelines. And they said that, because you can only impose a custodial sentence if it's like, the idea is only a custodial sentence will deal with this offending. But it might well be that the argument is, well, he's shown remorse, he's seeking treatment, he's suffered enough, etc., etc. Therefore, this can be dealt with by way of a community penalty. Now, of course, you also can have suspended sentences. The thing with the suspended sentences, that counts as a custodial. You can't actually downgrade something where you say, I think this should go to custody. I don't think this is that serious enough for custody, so I'll make it a suspended sentence. Courts can only impose suspended sentence where they think it should have been a custodial. However, there is something unusual about the offence itself. Theoretically, it's not the status of anything to do with the offender, it's just the offence. Then that can be a justification for imposing a suspended sentence. So it could be something like you were acting under duress, you were mentally ill at the time. I bet I just walked into like the middle of nowhere. There's no footpath here. I'll just I'll just wander around aimlessly. So it would. I can't imagine it's going to be a suspended sentence in this particular case, because there's nothing particularly unusual about the offending itself. It's just bog standard sort of possession. Nobody's suggesting he was forced to do it or anything like that, or he was only doing it for research, as some people have claimed and managed to get suspended sentences. Because it's not a justification to say I don't get anything out of this. I wasn't doing it because I was attracted to this. So there is no excuse that the law allows for actually like looking for these images. So yeah, I mean, that's why I am thinking it's going to be a high-end community penalty, especially if he says, oh, well, I will agree to sort of, treatment or something like that. Because, a lot of the time the argument is, well, send him to prison. It's only a short sentence. That doesn't give him enough time to actually do any of the anti-offending stuff. But also, you can impose what we call an SPO, Sexual Offending Prevention Order. And that can include things like, not having access to the internet, not having access to any electronic devices, all that sort of thing. I mean, sometimes it can be, not to go in certain locations, not to go near schools. So it wouldn't surprise me if there was an SPO in this case as well. So there you go. Hopefully the algorithm won't find anything too objectionable there. So, first of all, if you did find that vaguely useful, vaguely interesting, vaguely informative, please consider liking, sharing, subscribing. Although, like I say, I'm slightly less bothered about that now I've hit a nice target. And where am I today? I'm at a place called Carnbray, which is an old hill fort. Unusually, it is both an Iron Age hill fort, but it was also a Neolithic hill fort. I'll try and get some close-ups of things. That place where I started off, that's called the castle. It's actually right now a really nice restaurant now, really lovely family who run it. Unfortunately, the old guy who originally ran it, he's shuffled off this mortal coil now, but he was great because he used to just come at the end of the night and just get his bongos out and sit there drinking all your wine and just playing his bongos. But it's a bit of a folly, really. I mean, they call it a castle, but it was originally designed as a hunting lodge by some people with lots and lots of money, and then later on it was refurbished effectively just as a just as a little chalet by a rich family. And the big pointy thing up there, that's the Bassett monument. Bassett were a family down here that ran lots of mines, and apparently the workers loved them. They did a thing called 10 for 20. In other words, for every 20 shillings of tin or copper or whatever, because it actually made more money from copper mining than tin mining, they would actually give 10 shillings of it to the workforce. And that was a split of the takings, not even the profit. I am really now heading into like somewhere. I think I will have to just retrace my steps. I never like doing that, but I just can't see a way out of here. But anyway, apparently his workers loved him so much that when he popped his clogs, they actually had a whip round, and they had that thing built, which is quite spectacular. I'll get next to it in a second. I'll head over there and just take some more footage. But there you go.